quorum. But welcome aboard. I don't have an agenda. There it is right here. No, that's the lunch menu. The first item on the agenda, as I recall, is the approval of the agenda. Let me give a little background. This is a special purpose meeting that was called for the purpose of interviewing chief investment officer candidates, and has been scheduled for some time to begin at 9 o'clock this morning for that purpose. Mr. Gillespie requested and Mr. Powers requested additional items to be added to the agenda. So we've made some time to do that, and if the agenda is approved, we will address those in order. Do I hear a motion that we adopt the agenda?
I have some discussion first.
There needs to be a pending motion before there can be a discussion. Is there a motion that we adopt the agenda? Here's one.
I'll make that.
Is there a second?
So after the second, we have discussion, right?
Correct.
Yeah, so I'll second it.
Any discussion?
Yep. I had made a request to discuss an issue, and we had kind of a round robin email and a couple phone calls. I never heard a no, and then my request wasn't on the agenda. And the agenda was posted so late, there wasn't much time to kind of appeal it or whatever. Can someone explain to me how this process works?
I submitted and circulated a proposed agenda. Commissioners reacted to it and requested that items be added. Mr. Gillespie requested an item be added. You and 2 or 3 other commissioners joined in that request, and that's what's been added to the agenda. I didn't get a second request that from any commissioner other than Mr. Powers that additional items be added to the agenda.
I had a very specific request, and I put it in the form of a motion and everything, sent it to all the commissioners, and spoke about it with Mr. Adam, Jordan, sorry. Now I think I have it here. And it was that we, oh, here, I'm sorry, I left part of the stuff at the office. Anyway, my request was that we discuss the timber investment, because it's got several implications to it. Specifically, there's a lot about process, and as we go forward on a daily basis of sourcing and vetting and doing our proper due diligence on these meetings, I think it's important that we discuss it.
Well, that was Mr. Gillespie's request, and I thought what you did was join in his request.
I'm not sure what his request was. You never mentioned that. You mentioned something about correspondence and letters. That was
Yeah, with the last correspondence, we had the primary open item that we had as related to transition was your letter to me of, and then my response to you on June 21st, which directly relates to American Timberlands.
I could be mistaken, but I believe I received an email saying you joined in his request, and then 2 or 3 other commissioners, same thing.
Can we get these emails? Because I think when we look at the email train, I think that everyone will come to the conclusion that I did, that I made a very specific and distinct request. I took time to write it in the form of a motion, and I placed it for the 5 members and staff to see. There was never a response back. There was other miscellaneous conversation back and forth, but I don't see how it can be thoughts. Well, maybe I've got a copy of it right now.
Well, while we're doing that, can I ask a question of legal? Because, and this goes just to help me have a better understanding of sort of the FOIA and the posting requirements for meeting agendas, right? Because normally in a private setting, right, the agenda can be set at the beginning of the meeting as agreed to by the members and therefore amended. Because we're in a public setting, I know there's a 24-hour sort of posting requirement, right? Because all these emails were going on Tuesday, right? And I'm in the middle of the FINRA audit, so I wasn't exactly sitting at my desk in any great detail on Tuesday, but how do we sort of balance that tension?
The requirement under the state Freedom of Information Act is that agendas be posted no less than 24 hours 24 hours prior to the meeting. Does that respond to that?
And what about the specificity of the issues as listed on the agenda?
So, and the agenda that was initially posted had several items on there. I believe that what the chairman has indicated is that subsequent to the posting of the initial agenda, there were some additional requests made, and those were then sent out on a revised agenda prior to the 24 hours.
Maybe what Alan is asking, there's just some recent court case that limits the ability to change agendas.
Oh, indeed, and there is a recent decision that was handed down by the Court of Appeals, the Intermediate Court, which may well be subject to appeal. It's the Saluda County Commissioners case, and in that case, the Court of Appeals held that once once a meeting has begun, the body is not free to amend or revise its agenda once the meeting has begun.
Okay, and I'm fully convinced that I'm gonna lose this battle. Don't misunderstand me. I knew when we first started talking about the agenda that my item would not be on there, even though both chairmen had promised me that we'd be able to talk about this. So, but let me read at 1:49, which you will see was early in the process on July the 17th, a little letter, but I'll leave out the rest of it except for, therefore, I respectfully request that the discussion of the Timbo investment is presented on the proposed agenda, and that is it is in public session. Additionally, there is the possibility of receiving legal advice, discussion of certain facets of the investment, or discussion commission staff and members that may or may not necessitate us to go into executive session. But if so deemed by the commission and lawful, the commission may vote to move into the executive session as far as brief a time as required to fulfill our responsibilities and our stated goals of transparency and accountability. This was not a join-in. This was very separate and distinct. Talked about it with staff, put it in a letter. I'm fully prepared to be shut out of this. I knew it when it started, but I think I want to put it on the record now that I requested an appropriate, polite, and businesslike function, and that the chairman unilaterally ruled this topic off. I was promised in a letter from the previous chairman, and I was promised in a telephone conversation by this chairman that we could discuss this. I think it's important. If you throw aside the investigations, you still have the process part, which I believe are very important.
Any further discussion?
Yeah, I mean, I have just kind of a question, just, on this, just having been chair and so that there aren't misunderstandings on agenda items in the future, because of the 24-hour posting requirement. I mean, email is an inherently informal medium, right? But the posting requirement, and I think the way Robert's rules is for it to wind up being more formalized, right? So I guess one of my questions is whether all this email traffic, at what point does that actually constitute a meeting, or can you do a motion that gets approved on something, whereas in here, right, someone can make a motion, it has to be duly seconded, discussed, and then approved collectively, right? In essence, what we have is an email that got sent in a formal form, but wasn't responded
Well,
to.
let me ask a more basic question, and I should know this, I'm sorry I don't. Just how does it work? Who sets the agenda? Is there a process? Is there a written process that says this is what we do?
Oh, the governance policies indicate that the chair, in conjunction with, well, it says the CIO/CEO sets the agenda. That's really quite clear from the governance policies. But then we have, and by the way, I would note that it was my understanding that as with the combination of the open session item entitled Transition Issue Report, Commissioner Gillespie, plus the executive session item that does cover, could well cover if the members deem it warranted, could well cover receipt of legal advice, that we were going to cover the ground that you mentioned.
It's just not on the agenda.
Yeah.
It's just not on the agenda.
But that is my understanding of
And
subsequently.
so after, if he brings up or someone brings up the Timbo, then we can talk about it. Is that how this works?
That was my understanding.
Yeah, I believe that that's what Mr. Gillespie is going to be doing in open session. And then we will have the ability, if it is warranted and appropriate, to go into close, to receive legal advice, discuss investments, etc.
It's the best I can hope for.
Is there any further discussion? All in favor of adopting the agenda, say aye.
Aye.
All opposed? Gillespie, you're the next item on the agenda.
Sure. Open kind of transition items. I mean, obviously, the largest one that came up is kind of at the tail end of things was, obviously, the treasurer sent a letter. I believe everyone been in receipt of that. My response to him occurred on June 21st. What I thought were kind of appropriate issues for us to address at the next commission meeting, which would be today. What I basically laid out in that were things I think around this issues, the issues that he asserts in that letter are, I think, of a serious nature. They touch on several different areas. Subsequent to that letter and correspondence, some of the, do we need to put a copy of my letter or anything into the minutes?
If you deem it to be helpful, that could be done. But
Right.
I believe the commissioners have all received that letter.
I wasn't sure if Mr. Bloom here
Oh,
had.
okay. That's a fair point.
Kind of one of my
Okay.
questions. So just for the benefit of Mr. Bloom, in response to a letter the treasurer had sent on June 21st and my response of June 25th regarding various members related to American Timberlands, and I'm sure the treasurer, have you made Mr. Bloom aware of that? Has he seen a copy of your letter?
He's just that good. Let's keep him on my head.
Okay. So, basically what I laid out, right, is I think, we would need to confer with legal. There was questions about, whether or not independent counsel were necessary raised in a letter, whether a referral of the matter to ethics or the AG would be appropriate, or a referral of the matter to the governor's office. Subsequent to that, and I think it's pretty widely known, the treasurer's office has already sent that to the AG, and it is our understanding that that has also been sent to, consequently, to ethics as well. So there's really no action, I don't think, from our standpoint, on what to do with the issues raised in that. Other issues that do come up, again, it touches on areas that were new for the commission, but would be whether or not under our policies, do you have copies of those? Will you distribute those, please?
And this policy is no different than the last ones y'all would have received, it's just FYI.
Has everybody got one now? Okay. So again, I'd ask each commissioner to kind of review these. I mean, obviously, these are our policies and procedures. Some of the, I don't really know what to call them, I guess allegations or statements in the treasurer's letter touches on some of the issues outlined in our own policies and procedures. And then the question is, if under those policies and procedures, we would then go to, is page 15 in here? To the operations of the commission on any special elections. It touches on, outline of the state law requirements on special elections, removals, issues with the governor. So my understanding is at this point it's been referred to the AG, it's gone to state ethics. I'm not sure if that indirectly has gone to the governor or not, or whether any special notice action on our half to the governor's office. If there's any other issues that come up, deal directly with contracts, and I've asked legal to prepare to discuss those when we enter executive session later. So, That's just kind of an outline of where we are, what's occurred.
Given the referral to two outside bodies, I see no need for discussion of the matter here. I think it was the intention to have it discussed fully today. But that said, I've given a little thought to a motion which I will make, and we'll see what the response is. And my motion is this: given that the alleged conflict of interest has already been referred to the State Ethics Committee, given the nature of the alleged conflict, and that Commissioner Williams has a right to a fair hearing by a body external to the commission, I hereby move that the commission go on record as being supportive of an investigation of the alleged conflict by the State Ethics Commission. That's my motion.
Is there a second?
I'll second
Any discussion?
I'd like to discuss really this part of this timber investment, while it's important, was not my primary focus today. I do agree and appreciate the way the former chairman was prompt, and I think that his reaction and proposed actions were prudent, and I was prepared to leave them alone. Of course, I had a previous subsequent conversation with the new chairman, and his plan was no action. And so therefore, I thought that I just needed to go ahead and send. I didn't realize, Alan, when you and I were discussing this, that the chairmanship changed on the first of the month. I thought it was the first meeting. So that was, I probably wouldn't have involved you if I'd known that. Sorry, the last of your term. It was a gift you didn't need. I appreciate what you say, and I think we should. I don't want to belabor the point. It's a difficult life to be in public service. When you're in politics, you kind of get used to what people say about you. It doesn't really matter so much. But appointed folks, it's not as easy. And I don't want to belabor the point. I do think that there are some very important parts of this that we can't overlook that have to do with your motion, and I think it has to do with just process. And maybe, maybe this morning is not exactly the right time. Maybe we should have a meeting before September or October, whenever our next meeting is. But there are lots of issues about our due diligence and our process, and about insulating staff, about conflicts of interest. There are a lot of things that came out. I know that y'all haven't had the chance to go through the files. I have. I've been through it 2 or 3 times, and it's sort of a window into a world with which I don't think any of us are familiar, and it really warrants a lot of conversation and discussion. I don't want to grandstand this. You don't want to put it out there. If it's the sense that you say, hey, we got other things to do today, but we'll come back sometime sooner than later, I think that's fine. I'd be more than happy to. I do think that it's appropriate that your motion would go on record. I am troubled that with all the important things we have coming up, that the chairman has these problems now, and this is not a good time for anybody. I worry about the big decisions that have to be made. I reread these laws a lot. I've kind of gotten into a habit of keeping them on my desk and keeping them close. And one of them says that we have to look at all of our fiduciary responsibilities when they happen. We don't have foresight and we don't have hindsight. We have to look at it today. So if we make decisions, big decisions, we've got hiring decisions, consultants to hire, if we make those decisions and the investigations are fine and we're all able to support Mr. Reynolds when it's over with, then that's okay. But what if we make these big decisions, and these are as big a decisions as we make? What if we make them and things don't go well? Does it taint those that we've hired and that were involved in the process? I personally don't know the answer. I think I tried to put myself in this position. I think being the chairman is different from being a commissioner. I think I would step aside. And I think that we have able people here who can take the helm and lead us for this time and get us through this. And we wouldn't have to worry about that. At the end of the day, our most important responsibility is to protect the trust. How do we protect the trust in this issue? And so I agree with your motion and speak for it. I don't know if it would be appropriate to amend that, but I think the chair ought to step aside and that the vice chair should assume responsibility for the commission until such time as we're as we receive a positive or receive information back from the investigating bodies, both SLED and the Ethics Commission.
Mr. Treasurer, let me pose a theoretical question.
Can I maybe
Go
call
ahead.
one order? This is a separate issue than the motion. If we
Okay.
could just get to a vote on
Call
the
the
motion.
Okay.
Call the
I'm
question.
sorry. Call the question.
All in favor of calling the question, say aye.
Aye.
All opposed? Okay.
Well, that was to call the question. Now we got to vote on the motion.
Right. The
What
motion,
What were the votes?
I think it was unanimous.
And can we read the motion one more time?
Yeah, please, I would agree with the treasurer, I'd like to hear it again.
I was there again on handwriting last night. The motion is this. Given that, number one, that the alleged conflict of interest has already been referred to the State Ethics Commission. Number two, the nature of the alleged conflict, and that Commissioner Williams, number three, that Commissioner Williams has a right to a fair hearing by a body external to the commission. I hereby move that the commission go on record as being supportive of an investigation of the alleged conflict by the State Ethics Commission.
Would you take a friendly amendment to add SLED as well, since it was referred to them as well?
I'm willing to take that motion, that amendment, yet my own feeling is, had we dealt with this matter on our own, we probably would have just referred it to the State Ethics Commission, and that's why I limited it to the State Ethics Commission.
But as a practical matter, it's already been referred to the AG.
Correct.
The AG, is my understanding, is the one who gave it to SLED. Is
Yeah,
that
so as a
correct?
practical matter,
Right.
I have a problem amending it.
One. And
Well-
correct me if I'm wrong, but my understanding was it went to state ethics and the AG sent it to SLED. Right? So-
No, wait, can I just make sure everybody's clear about the facts? So we received confirmation from the Attorney General's office that two steps were taken. Once the Attorney General received a letter from Treasurer Loftus. Step number one, the Attorney General asked the Ethics Commission to review that portion of the Treasurer's letter that dealt with the ethics law. And step number two, the Attorney General asked SLED to review other aspects of the Treasurer's letter. Two separate steps. And just to be really clear about it, the Ethics Commission's empowered to act on potential violations of the ethics law without reporting back to the AG's office. They can handle it, dispose of it on their own. Whereas SLED will be, our understanding, it will be reviewing this matter, reporting back to the Attorney General, and then the Attorney General will decide what, if any, action to take. So those are the two steps that were taken. I think the motion having been duly made and seconded, this friendly amendment now would have to be ruled on, Mr. Chairman.
I'm gonna pass the gavel to
Okay.
Vice Chairman on
Okay.
that. The metaphorical gavel.
What
There's on the table is a motion that was duly made and seconded, but made by Dr. Pritchett and seconded by yourself, before you became chair. Now we have a friendly amendment, and the question is whether that amendment is going to be added to the motion. And the maker is not opposed to amending. Okay. Is there consensus? that-
Can we read? Huh? Yeah.
I'm sorry.
Exactly what is the amendment? Is it Attorney General or?
I think it was adding SLED, I believe.
But would it be more correct to change that to Attorney General?
There's an investigation going on right now by SLED. That is what is happening right now. And then we could reference the Attorney General's ultimate involvement too, if the maker of the motion.
Who's not?
And Nancy,
No.
now that so now the friendly amendment now has to get voted on, I believe.
Right. Whether to amend the original
Right.
motion.
Mhm.
And so I would suggest that the motion be restated.
Okay, one more time? Okay.
as with the
With
proposed
the amendment.
amendment.
Okay.
Could I just begin from I hereby move?
Yeah, absolutely.
Okay, so it now reads with the amendment. I hereby move that the commission go on record as being supportive of an investigation of the alleged conflict by the State Ethics Commission and the State Law Enforcement Division.
Mhm.
Read that one more time.
I hereby move that the commission go on record as being supportive of an investigation of the alleged conflict by the State Ethics Commission and the State Law Enforcement Division. And of course, the amendment is adding state law
Right.
enforcement.
Yeah, well, I think we should be supportive of it. In fact, I've instructed commission staff to be supportive of it. So I want to avoid the implication that the commission has reached some conclusion
Right.
that requires us to report
Right,
that.
that's the reason I said being supportive of an investigation of
Absolutely.
the alleged conflict. They call it conflict, or the alleged conflict.
Everybody understand the motion?
Right.
I guess probably call for the vote.
Call a question.
Call the question. All in favor?
Aye.
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 Any opposed? Motion's carried unanimously.
Thank you.
So, if I may just continue just for a second, the treasurer talked about, kind of in the discussion of the prior motion, the issue of chairmanship, right? That we do have in our policies and procedures, which I asked everybody to review, provision for special elections on page 15. So wanted to make people aware that we do have that provision. We don't really have what constitutes a trigger for calling us said special election, but wanted to make everybody aware that it is in our policies and procedures. You know, if there were a motion to be made, I think it would be appropriate for it to be made and discussed, but it is in our policies and procedures.
Is that all?
That's it.
Do we have a sense that the commission would like to get back together at a sooner than rather date to discuss the demolition? On a day where we don't have quite
Yeah,
such a...
there's a third issue that derives out of this, which directly relates to the contracts on American Timberlands, which I think we fully need to discuss when we enter executive session. But I think those are well covered in executive session.
Shall we leave the idea about a meeting until after executive session?
So the commission is.
Let me resume the chair now.
Yes.
Okay.
Are you making a motion that
I
that we
haven't
later
made a
go into
motion.
executive session? to do
I haven't
that?
made a motion, but
Okay.
I'm just making people aware that there was, the issues around this was, one, what to do about the information in the letter we received. We addressed that, because that information's already been passed on. The second issue had to do with, under our policies and procedures, whether somebody wanted to call for a special election. And the third issue relates directly to contractual matters, and contractual matters clearly would take us into executive session, which we already have scheduled later in the meeting.
Okay, well, the reason I'm inquiring about that is if we end the executive session and we haven't voted to go into it for the purpose of that discussion.
Right.
But if you're not moving that, that's fine.
I haven't made that motion.
Okay.
I assumed I would make that motion after we do Jim's things. following.
Okay. All right.
I'm gonna bore the hell out of all of you.
All right, does that conclude your transition report?
Yeah, that's all I have.
Can I do two quick housekeeping off of that, which is one, could we just have the letters back and forth from me now and all that read into the minutes?
Read into the minute?
Well, I mean, I can read them and present them, or
Okay.
that's what they call it, send it when they dump it in.
We can just include them as
Thank
an
you very much.
exhibit.
Yes, thank you very much.
Added as exhibits?
I'd like to review it before those become an exhibit, because I'd like to know where it is. What I have is an email chain that began with Mr. Gillespie, followed up with Commissioner Loftus expressing agreement with it, followed up with Mr. Joby expressing agreement with it, followed up with an email from Commissioner Loftus saying he agreed with Alan's approach. And that's the email chain I have. So I'd like to see it before it actually becomes a decision.
What,
Yeah, I was referring to the
Okay.
letter of June the 21st
I
to
thought- oh, okay.
Gillespie, and back to
Okay.
me, and then back to Al, and Mr. Gillespie, and then to the Attorney General.
is that the only set of
Yes.
documents? Okay, okay, thank you.
Okay, next item on the agenda, we're a little bit behind, but not much. Jim usually is not overly loquacious, so take it away.
I will catch us up real quickly. And after the previous discussion, I'm sure bore everybody in the room. I think some good points were made with regard to timing of investment decisions. So let's get back to what we're supposed to be doing here. I was chairman during the policies and procedures process, and I think that I would like to propose, and I'm not making a formal a motion right now, but for discussion, that we should, from the point at which an investment decision is made and presented to the commission by staff and by a commissioner, that we should wait 30 days before that's voted on. That would give everyone time to read all the documentation. We are fully diversified now. I don't think it does not disserve the trust. So from the point of a presentation being made to the commission by staff about an investment, that a vote not be taken for 30 days. I just picked 30 days for 30 days, 60, 90, I don't care. But we wait, and that way everyone has sufficient time to go back and read the documentation. They can get on the internet and review who this person is 30 days before a final vote is taken. I do not think that disadvantages the trust at all to wait 30 days. Secondarily, I believe that then you go, then the decision is made and we vote, and if the majority votes that this is a good investment, we're going to do that, then you have a contract period. And I think that that takes some time for staff to negotiate a contract and this and that. I believe that after the contract is negotiated, before the chair signs it, which has been our custom, I believe that there should be an additional 30 days for that contract to be circulated to the commission so that they can look at it and review it if necessary. And then, after a 30-day period, if there are no comments, whatever the comments are, then the contract's signed. So it's really, I'm being long-winded, which is not my custom. Very straightforward. Presentation to the commission, wait 30 days before a final decision is made and voted on. Everybody has a chance to look at everything that's been on the table with regard to the counterpart. After that decision is made, if it is affirmative, then we go through the contract negotiation. Legal counsel will come up with a contract. That contract is circulated. And then there's an additional 30 days that everybody has a chance to review the contract, look at it, make comments one way or the other. And at that point, then the contract can be signed by the chair. I think it will take a lot of the, I just think it's, for lack of a better term, just a good idea. I mean, let's put some timing between all of this. So that's my thought, and I'll make it a motion if someone would like me to make it a motion, but it's just an item for discussion that I think would take, I just think it's a good idea.
Just a question, excuse me. I want to be clear, are you suggesting that at the initial 30-day period, at the end of that 30-day period, after everyone has had a chance to
Right.
examine all the information, documents, whatever, that it would be voted on by the commission?
Right.
But then, after that, there would be an additional 30-day period for additional examination?
Well, no, well, actually, after that, the commissions would affirm the decision. After that, then you've got to go to contract, and that could take God knows how long. And I'm not denigrating lawyers here, my son is an attorney. But, you know, after that, then you go to contract. And then everybody gets a chance to look at the once contract is pretty much decided on between the attorney, then another 30 days. Everybody can look at the contract, 30 days, and then the decision, and then the chair, is customary policy, would sign the contract. I'm just saying that
Just closing the
closing the loop and taking time so that everybody has a chance to examine everything that's, 30 days is just a number. You could make it 10 days, you could make it 90 days, I don't care one way or the other.
Let me, go ahead.
I'm sorry. But just again, just to clarify, at the time that the investment is, the presentation is made,
Right.
and during that 30-day period, during that time, are the contracts in the process of being drawn up and fully completed by the time of presentation to the commission, or is that come after the approval?
presentation is made to the commission by staff, Herschel, by whoever the commissioner is. The presentation is made. The commission hears everything that's being discussed, and then there's a 30-day period before that decision is either affirmed or denied.
Here's a point of clarification I wanted to ask you on this. When you say a proposal to the commission, would that include, for example, staff having their recommendation, emailing us the stuff in advance of the meeting?
Sure, everything,
Okay.
it's sort of the same process as goes on, but, you know.
Okay, so it wouldn't, you're not saying it should be done at a meeting and then 2 months later is when it'd be voted on, but proposal would encompass email or other communication?
No, I'm saying that from the time it's presented publicly to the investment commission, there'll be a 30-day period before it is approved.
Maybe a simpler way to do it rather than having it steps, right, is when it's presented to the commission, have a preliminary approval, but no final approval will be given until 30 days after a final contract is presented to the full commission.
However
long that
what I'm
takes,
trying to get
right.
on the table
So,
is
yeah.
a period of time that everybody has a chance to review what we're doing.
Right.
Yeah, what you're trying to do is
So I'm just saying, whenever we
avoid two
get the
separate
final,
votes.
2 separate votes,
Yeah.
one's an indication of interest, that basically saying, okay, we're serious about this, let's get into negotiation and hammer out final documents. Second vote is, we got final documents, we've had 30 days to look at them, let's vote.
Yeah, that's essentially it, but I don't have a problem with that.
You said you were, I'm sorry, Travis, go ahead.
I think this is really important. Jim, I really get frustrated getting something like the day before the meeting, 2 days before the meeting. You know, you're busy with something else, and, you know, it's very difficult to be fully informed at the time of the vote. So I think it's very important, and I think a change is needed. What concerns me about it, and I think ought to be at least brought into the discussion, is that it's my observation in working with private equity that we often get a shot at a fund when final close is very close. And I don't know why that happens. I don't know, you know, whether we are not, they are on their preferred list and we kind of get brought in at the end or what. I don't know why that happens, but it is often the case, and so it makes it that much harder to get in on some of these deals. Would you want to comment on it just very briefly, Dave?
I can, if that's fine. Okay, thank you. Yeah, there's, in some cases, to, you know, in regards to Commissioner Pritchard's comments, there'll be a certain timing of closings for private equity and real estate. In many cases, you know, as part of our due diligence process, we'll be very thorough and very detailed, looking at the managers, doing reference calls, meeting with the teams, not only the deal team, but the operations team. And we're going to be very thorough and very detailed, which will take some time on the front end. During our process in which we're doing this due diligence, they are going to be having first closes and second closes with groups that may not be as thorough and detailed as we are, or may have been previous investors in prior funds that these managers have established and are already very familiar with the organization, where we're coming in maybe in a later fund, but aren't as familiar because we don't have that same history. So in relation to Commissioner Pritchett's comments, we are coming in later in the process. Now, if we have a period of 30 days to kind of evaluate what we're doing and to vote, and then have another 30 days to review the documents, that's going to put a lot of challenges on legal, it's going to put a lot of challenges on investment staff to make sure that we hit that closing, because we don't drive that closing date, the manager does that. So that's something that we're going to have to work around. So if it's 10 days, that may be a little better. When we put 60 days into it, Commissioner Powers, that creates a little bit of
I
a
would've said
challenge
30
for us.
days.
So-
I think
So-
30 days
Yeah.
for formal documents, I mean, I think, you know, and
Talking about total-
internally, we just gotta get in gear.
Yeah, but you're talking about 30 days total.
I'm thinking we have a preliminary indication of interest, right? That allows you to go to negotiations to get the final contracts. I think what we're asking for is that everybody wants the final contracts 30 days before we have official approval and commit the trust to it. I don't think that's unreasonable. So, I mean, obviously, we have to have something that is a sincere indication of interest that gets us to negotiations and a final document that people can see. But, I mean, the key, I think, Jen's proposing is that we have 30 days to look at the final document once it's all hammered out.
And, Mr. Chairman, if I may, does that include subscription agreements? In other words, what I'm understanding is investments proposed, preliminary approval, 30 days, y'all vote on it, and then if you approve it, are we supposed to negotiate the contracts in that preliminary period?
Yeah, that was my idea. I mean, I
Okay. And-
can't believe this has gotten so complicated, but I
And
guess,
so-
you know, it has, I'll withdraw the whole damn thing if you want to, but I mean, but, Nancy, come on.
With
I
all due
understand what you're
respect,
saying.
I understand what your goal is, and I personally think it's moving in the right direction. I'm trying to get clarity on how to handle the contract process, given
I will,
the
I
various components
will, I
of
will
it.
clarify it.
Okay.
God. The commission approves, after 30 days of reviewing everything that's been presented, the commission, after 30 days, has a chance to look at it, for 10 days or 5 days, I don't care. An investment for the trust, for the retirees. I think that that's appropriate. Then, once it's approved, then your staff goes and works with regard to the contract. Once you've come up with a contract that you deem agreeable, before the chairman signs it, there'll be a review period of some period of time where everybody can look at that contract. I was gonna get to the who can look at the contract later, and I think that should be expanded too, but and maybe this is something we should talk about, another time or later or whatever. I just think that there needs to be more time between, there's been a good bit of discussion about how quickly we move on things and how much time commissioners have to look at things and how much time there is between a decision and a contract. And I think that if we give more time for everybody on the commission to look at that, it would solve that problem. With regard to your comments, I take your comments about private equity to heart, and I think you have to go to balancing how quickly you want to make a decision versus the public trust. And I'm not sure that I'm qualified to make that. Well, I'm absolutely sure I'm not qualified to make that decision. But I think that's something that needs to be balanced. And I didn't mean to open up a whole can of worms here.
Jim, would you be comfortable, there's broad consensus here and before the Budget Control Board that that's what we want to do, we want to move to that. Would you be comfortable with asking staff
Absolutely.
to prepare
Absolutely.
a recommendation?
Absolutely.
With this broad consensus? I can think of a lot of ramifications, like requiring them to give us their desired contracts as part of the due diligence process. And that way we can be looking
Right.
at least identify them.
Absolutely don't have a problem.
And
but I
let's get
can't-
them to report at September.
But my concern, I don't understand how the suggestion that we extend the timeline to give everybody more time to make a decision is controversial, but it seems to be. But absolutely, I'm happy to turn it over to staff or whatever. God, I'm sorry I brought it up. I mean,
Well,
you know,
in actual, yeah, I think so too. In actuality, a lot of these times, these closes are way off. I mean, now I started reading them, y'all do a fine job, staff does a good job, and they sit there for 6 or 8 months, and then they pop up again. And, there's a lot, so there is a lot of flexibility. I do think we need to be careful about letting this not be a commission decision. I think you're on target. I think everybody, all the commissioners, in one way or another, believe with you. I don't want to see this get dragged down. Too many times, when things leave us, they go to staff, and they come back in different forms. And we just think we end up arguing about them forever. I think that your idea here has great appeal. At some point, we might lose something, but I think we also gain a lot in every bit of your proposal. So I think there should be a motion. I don't want to vote on it. If we have to tinker with it along the way, we can. But if we don't, what'll happen is it just won't get done.
okay, I'll make a motion, and then we can vote it up or down.
What's the motion?
My motion is that go ahead,
I can make a stab at it.
please.
I make a motion that we don't move to final contract unless each commissioner's had a minimum of 30 days to look at all final documents.
I'll second that.
Any discussion?
Mr. Chairman, if I may.
Yeah.
I actually like the solution that Mr. Powers has put forth, and glad to see some agreement solutions and how we can address the process itself, so there's more full vetting and more appropriate time for more commissioners to review documents as appropriate. I think that there are a lot of devils in the details, if you will, with respect to the actual implementation of the policy itself, because we want to balance out. There's obviously the confidentiality natures of various things as you're in contract negotiation. There seems to be a lot of documents potentially floating out, and I think we have to be careful to protect the trust, especially during a phase where we're negotiating and things have not been finalized. So I think there are some things with respect to the actual implementation of it that really need to be honed out and discussed so that we're all on the same page and that we can accomplish everyone's tasks while not endangering the trust during negotiation phases for these contracts. I do like the idea of having, I guess, like the cool-off period or review period post the presentation. But then I think that in itself raises the question of, do we move from a quarterly commission meeting schedule to then a monthly, or how often will we then begin having commission meetings? So I think there are some things like that we need to consider. But the overall idea presented by Mr. Powers, I think, is definitely the right track of where the commission will want to go direction. But I think there's some other components that need to be thought through.
Yeah, I think we can figure those out, even if it's just the last final closing thing, we can all come to the office and look at it.
And so I wasn't sure of the implications of your
Right.
motion and how that becomes effective and what are all the details under that. And that's my concern.
I think we can work through those.
I think so too.
Even under your motion, the commission would have the power and ability to vary from that 30
Yeah.
days with regard to any particular investment that we approve. We can always vote ourselves different.
Right.
Sure. Yeah.
We can figure out document handling and stuff, I mean, those are operational details.
May I suggest then, if we do move towards that direction, then staff have the ability to come back and fill in and flesh out some of those details with respect to the implementation before we do the
Absolutely.
commission? Because I want to make sure that the staff is fully aware of what the expectations are with the change to the process.
Yeah, if this motion passes, yes, we should do that. But I think you be aware
Bear in
that.
mind, we're giving staff more time. We're extending the process. We're giving you more flexibility. We're not limiting anything here, I don't think.
And we're just asking that more people than just the chairman have the document,
Right.
and that he has more,
I
on
mean-
a weekend,
Have access.
yeah, have access.
Right,
than-
that's all.
than a-
I mean,
than
so I don't
the
think,
next
I don't think we're
week.
limiting anything. I think we're, anyway.
All right.
I think just,
We're gonna have to change our standard motion,
Yeah.
for
Mhm.
approval of it.
Right.
and I think the recognition that we do have a mature portfolio that a lot of thought has been given to. And we're not in the, the shape y'all were in the last 3 or 4 years when we had to get money out the door. I think it does give staff a little options they didn't have. But anyway, if there's a motion for it, is that correct?
Motion has been seconded, I believe.
Any further discussion? All in favor, say aye.
Aye.
Ayes have it. Jim?
Yeah.
We're still late.
Um, I'm not going to make this in form of a motion, but I think it's something that the commission should consider. And I sent an email to all the commissioners saying that I would not discuss this with any commissioner, and I have not. First thing that I brought up, I thought would pass in like 2 minutes. And it's taken 30 or whatever. I believe that we should, with regard to the confidentiality discussions, I believe that it should be extended. I believe, and I have not talked to the treasurer about this, I have not talked to the chairman about this. I believe as a taxpayer and a citizen that we should extend the availability of contracts beyond the existing level. And I don't have a motion to make, but I think that Budget Control Board members and perhaps 1 or 2 members of their staff should be able to look at these contracts. I believe the Attorney General should be able to look at these contracts. That's more of a statement than a motion. And the treasurer and I have disagreed on a good many things. We've agreed on a good many things. But I think that it's important that the retirees trust us. And my concern is that they do not trust us. And I think that that's our fault. It's not any individual's fault. And I believe that we should reconsider who sees those contracts and make it, and I know there are a lot of legal, I know Nancy's probably cringing over there. I understand that there are, and Robert, I'm sorry, there are a lot of things that should be considered, but I believe that that we should extend the availability of the contracts. And I think that there are a lot of words that are being tossed around that are, private equity. And I think the public looks at that and they think, oh, private equity is some sort of scary thing. Private equity, Krispy Kreme donuts. How many people have had one in the past, 2 or 3 months? Microsoft, how many people run that on their computer? Staples, so private equity is not a scary thing, and I think that those contracts, I've been a very fortunate guy. I grew up in a mill village with parents who didn't finish high school and ended up running an investment business on 4 continents. But I've never seen a private equity contract that didn't have a confidentiality clause. They just don't exist. Maybe they do. But I think there should be more people available to look at that sort of thing. And I had thought about making some sort of motion to include more people, but it's not probably appropriate right now. But I do believe that that to a certain degree we have lost the public trust, and I don't believe that's anyone. As I said, that's our fault, and I think it's unfortunate. And I think today we have a chance to move ahead with regard to hiring a new CIO or retaining Herschel. And it's just one of those things that that I wanted to get off my chest. And now I have, and we can move on.
Would you, I appreciate that, and let me tell you what I've done, and which I think is consistent with what you're talking about. I haven't signed a contract since 4 years ago, whenever that was, 2008. So, and I don't think we did any private equity or anything back then, so I don't, when I signed them, I always assumed that a contract once entered into became a public record. That was just my assumption. And I never gave it much thought after that, but I have now learned that because of private equity and various constraints that we have signed a lot of contracts that have confidentiality provisions in them. And I think we have to honor our contract. But I have asked the legal staff to categorize all of our contracts that we've signed. How many have confidentiality agreements, what kind have confidentiality agreements, and be prepared to report back to us in September on what's the magnitude and scope and nature of the issues that we'll be facing, and then have a recommendation on how to move forward on that and how to if possible, remediate some of the past problems. And it could, it can include the whole gamut of remedies, such as canceling a contract, starting over. Some of them we may not be able to do that. It may put the funds at risk if we try to handle it that way. But I think to me, the first step is to analyze it and see where we stand and what the ramifications would be if there is course of the contract.
Of course, I want to weigh in on this, and thank you for your recent comments. We've talked about this a whole lot, and I am going to put a motion before, because I think we need to vote. I think the retirees deserve to vote. I think the taxpayers deserve to vote. I think outside of this room, I've never met anybody that believes these confidentiality clauses say what they do. I've talked to strategic partners, I've talked to our fund managers, I've talked to consultants, I've talked to lawyers who write these contracts for the hedge funds. I've talked to state lawyers, I've talked to politicians. Outside this room, I can't find a soul. And it's caused a lot of heartburn, it's caused a lot of problems. I think that we need to go on and vote. I have a little motion here. I'll make it, because I think we need to vote it up or down. I think everyone should see where we stand. And I'd like to make the motion that government staff of a fiduciary, to include the Budget and Control Board and the State Treasurer's custodian, should have full access to confidential material. The access shall be decided by the fiduciary upon need and credentials of the staff. The fiduciary staff who receives this information shall maintain its confidentiality in accordance with state law. All future contracts should explicitly provide access to fiduciary staff.
Could you read that one more time, please?
Yes, sir. Government staff of the fiduciary, to include the Budget and Control Board and the State Treasurer as custodian, shall have full access to confidential material. The access will be decided by the fiduciary upon need and credentials of the staff. Fiduciary staff who receives information shall maintain this confidentiality in accordance with state law. All future contracts should explicitly provide access to fiduciary staff.
I'll second that motion.
Travis?
Could I ask you to explain what you mean by fiduciary will decide? Who's the fiduciary in that case? I mean, all these people, the Budget Control Board members,
Yeah.
fiduciary.
That's right.
Now all the members of people are going to be code trustees, and they're fiduciary, all us fiduciary.
Sure.
I mean, does the commission decide, or?
I think, yeah, the way it works now with with the elected officials, the Budget Control Board and the Treasurer, we have government staff. They help us do all sorts of things. And those would be the staff. Like in my,
Who will decide, who is the fiduciary, who will decide?
the individual fiduciary, like the Treasurer's office, I would probably need a little more access than, say, the Governor's office.
Are you saying we would decide?
Yes, sir.
Who gets
That's right.
access?
That's right. Because we have, go ahead.
This is what bothers me for some time. I see the need for you to have access. And for example, if you send your attorney, the attorney has certain credentials, they have certain ethics in their profession and so on. But if you just send a staff member, I don't think you mentioned the word credential. I don't know if they have any credentials. They may have great credentials, they may not. They may be able to interpret what they read, is the point I'm trying to make. They may be somebody with proper finance background, for example, who can read these contracts and interpret what they mean. But it might be somebody else without any finance credentials who might misinterpret something they read and take it back, and, you know, I just see problems if any staff member of the various fiduciaries get access to
Well, the
something.
Let me
the
read.
fiduciary, of course, would be responsible for that. But, you know, like right now, say, if it becomes a banking issue, well, I have to include my banker. But most of the time, it wouldn't be a banking issue, it would just be a legal and an investment issue, that type of thing. So, you know, if you tried to, and the governor was to have a different set of staff, and the, say, Senate, the finance chairman would have a different set of staff. We'd all have different people who have to look at them. And there would be some occasions where, in many occasions, where nobody would have to look at the contract. But if there were a controversy or a contract that became problematic, of course, that staff may vary. But they would all have to go through the same vetting. You'd all have to be, you go through the training, you'd have to sign confidentiality agreements, you'd be subject to the state law. And of course, we deal with confidential information every day.
Right, I mean, I guess, I think it's a little preemptive to act, right? I mean, the Budget and Control Board, you know, passed a motion the other day to hire a fiduciary counsel for the full system. Personally, I would like further guidance.
And I agree 100%, and I have been leaning that way myself. But the problem is, it's still just going to be an opinion. We've got Attorney General's opinion, we've got lots of opinions. But I'm headed, in my thinking, especially with the events of the last.
One of the other things we have is state law, and I don't think this commission has the power to amend state law to change the definition of a fiduciary. Section 9-16-10 specifically says in the context of the Retirement System Investment Commission that a fiduciary, and it's one of 4 specified categories, A, exercises any authority to invest or manage assets of the system. B, provides investment advice for a fee or other direct or indirect compensation with respect to assets of the system, or has any authority or responsibility to do so. C, is a member of the commission, or D, is the commission's chief investment officer. Those are the fiduciaries. And I don't think the commission has the ability to expand or subtract from that.
Well, I mean, we've expanded it here just in the last few days. In the COO job, we make that person a fiduciary. It's in the contract, I mean, it's in the posting. We granted that without a vote or anything. Secondly, I was unaware that the Budget Control Board was not fiduciaries. I thought their system as trustees made them fiduciaries.
But they're trustees, but for the purpose of our statute,
Well, then maybe,
these are the fiduciaries.
well, then I should put trustees in my motion. Because they hold the trust, and they own the trust, well, they hold the trust and they own legal asset. The titles of the legal assets. They have personal responsibility. But my purpose here is to put this out for a vote.
Right.
And, oh yeah, if 916-360, I think that's important. We should probably go to that. It deals with employees of fiduciaries as well. But even that doesn't address my problem, which of course is part of this overall problem. But, you know, even though the law is clear that I'm a fiduciary, we haven't granted it to me. And that's, you know, it's a corollary to this conversation. I cannot continue to work in the hours I'm working. It's going to cause a real problem. In fact, first when I changed letters, I just cannot be available all the time for documents to come over. It's a real, you know, the business model to have one person responsible for this is just not going to work. So we have practical applications, but we also have the theoretical application here, or the principle behind it. These people are in court case after court case, they've been called, the trustees have been called fiduciaries. I know I'm a fiduciary, I'm a named fiduciary. I don't know what the people's status is going to be. Of course, people is going to have, they're going to have lawyers too. So I suppose you're going to have to fight your way into this as well. It's just a system that doesn't work. We limit it in the confidentiality here, which is based upon, I think, a misreading of the law and of the contracts. And we're going to fight about this forever. We need to get a vote on the table so that the board and myself and others can have a semblance.
Yeah, I mean, again, my stance is that the board, on behalf of the entire system and all the covered bodies, you know, We are lower down the totem pole than the Board of Trustees. They have engaged fiduciary counsel. I would like some further guidance from them before taking action.
So you moving to table this motion?
Well,
Well, I get, just a comment,
Yeah.
and I think you have a very good point. If we, whatever we do might be premature prior to whatever this, what do you want to call it, special counsel?
Their fiduciary counsel.
Whatever,
Their fiduciary
they
counsel.
make, presumably, they're going to come up and tell us what we should be doing.
Well, they're gonna tell us what we should be doing on a whole lot of issues. They're looking at everybody from PIBA to us, everybody's roles and responsibilities. That's their, it's not just about confidentiality, it's about all of these issues. Exactly, what are we supposed to do, what are we responsible for? So this is just one part of it. And I understand exactly what Alan's saying, and, you know, I always respect what he has to say. But I'd like to have a vote, because we've been talking about this for 8 or 9 months. It's stymied us, we're always gonna fight about it until there's some resolution. And this council thing could drag on for months and months and months, literally. And so where are we gonna be in 6 months? I can tell you, I cannot be at the ready to
I
sign
mean,
these
my
documents.
concern is we have existing contracts in the ground. I think what we've negotiated on this front on the last couple of contracts is totally workable, right? If we suddenly throw this open and information gets out, we now have, you know, and this is kind of a big concern of mine, but compliance issues, right? Who reviews personal trades of every individual that has information that comes through there? I don't know, right? That's a real issue. I'm going through SEC and FINRA exams right now, right? So, you know, are we collecting data on everybody's personal accounts? I don't think we are, right? Second issue is that do we unintentionally get breach of contract if one of these things leak out, right? And if there is a breach, where's the recourse, right? So personally, I would like further guidance before we throw open what in my mind is a whole host of liabilities without clearer guidance from fiduciary counsel for the system as a
Well,
whole.
we've ignored the opinion of the Attorney General, so we certainly can ignore an out-of-state law firm. We've got all the things such as getting personal information on folks. That's procedural. I mean, you just have to do that. I mean, you know, we came here, when I came here as elected official, I had to sign documents. We all have to do that. So all those things are, again, like the earlier motion, they're just procedural. You have to do it. If you don't sign them, you don't sign the contracts, the confidentiality clause, you can't see the stuff. I mean, we all have these rules we have to operate by. But we're gonna just be, for months and months, waiting on this thing to come. And then if we want to ignore it, we can just ignore it then. So, you know, I'm looking at how this is gonna play out, and I'm looking at the treasurer's office. We just can't sustain this business model. I cannot do it any longer.
Question, Mr. Treasurer. It seems to me that there's 2 aspects of what you brought up here, which would be to, if we were to pass your motion, it would broaden out substantially access to contract confidential information. It also appears to me that there is a specific problem, which you have, which is that you individually cannot
Yes, sir.
cope with a caseload of reviewing all these by you singularly, and would require additional help. So maybe what we need to do is to kind of separate the 2 out a little bit, and somebody needs to help me here. Is there a way that we can accommodate the needs of the treasurer in terms of his inability to singularly?
Well, can I just touch on that?
Yeah.
And correct me if I'm wrong here, but take the Budget Control Board as trustees. There's no question in my mind that we can deliver documents to them. If there's a breach, provide them access, right? What they decide to do with it at that point, right, becomes their responsibility and their liability, right? Same thing happens, you know, if we send it to the people board, right? So I think there's a difference in providing information and then, you know, because back to sort of who's responsible and, you know, if a breach or something occurs, right? And I don't think it's at our place to unilaterally go and make decisions on behalf of those bodies, right? About who in their staff should or should not have access to them. I think we provide it to them in their capacity as trustees. What they decide to do from that point forward is their responsibility and issue.
Mr. Chairman?
Go ahead.
Thank you very much. Just a couple of comments before you all vote on this motion. First, I greatly appreciate the direction that the chairman has set on this topic at the Budget and Control Board meeting on July the 12th. As I hope all the commissioners recall, the chairman set out indicated a direction in which we are going with regard to existing contracts and with regard to future contracts. And the chairman has just elaborated on that plan a few minutes ago. We are already taking steps to provide greater access to information to folks at the treasurer's office, and we're going to try to keep working on that. I do appreciate Mr. Gillespie's reminder, however, about the meaning and significance of the action taken by the Budget and Control Board at their meeting on the 12th, appointing external counsel to review roles and responsibilities. And I do think it would be quite beneficial to permit them to ultimately weigh in on this and provide further guidance. We are not ignoring the opinions of the Attorney General. We are obviously trying constructively to work with the Treasurer's Office and others on this issue. And accordingly, I do not see the benefit to trying on the fly to modify and amend state law or make an interpretation of state law. And if I may, just one last request to all members of the commission. Several items that have come up in today's meeting are really quite weighty, really quite important. And you can think of me as your son, perhaps, the lawyer's son on this. But we would greatly appreciate, I do believe I speak on behalf of all members of staff as well as legal counsel, we would greatly appreciate the opportunity to perform our jobs as your staff and as your legal advisors, to receive your ideas and suggestions as well as your guidance, but to have an opportunity to review it and come back to you with our best thinking, the listing of pros and cons, so that you all can ultimately make the best possible, best informed decision and be able to say to the stakeholders, yep, there's been a great and thorough dialogue, and here's the decision that was made.
Mr. Chairman.
Yes.
Firstly, I don't think it is the responsibility of the fiduciaries to ask staff permission to do certain things. We are in that role, and we do not have to pre-clear our ideas and our suggestions. I don't think anybody here has suggested anything that's revolutionary. In fact, we've asked staff to work out the details. But what we have done here for years now is to allow staff to dictate things. This whole confidentiality, which is a stain on this organization, is going to have to be solved in court. It's just the way it is. I mean, because it can't keep going. We are firmly in the Treasurer's Office. We're making a move. You said you're giving me more information. You're giving me more information. Me more information. Now, this staff is, how many people do you have now, Herschel, to help you? You have a lot of folks to help you. I don't. I've got me. And I can't do it. So we cannot count on a steady stream of funds coming out of this Treasurer's Office, because I cannot continue to work the number of hours that I am. It just isn't going to happen. I have to at some point say, I cannot do it physically. So that's a real problem, and that's going to necessitate some action by me. And I'm going to put my vote on the table, because I want the governor, I want the attorney general, I want everybody to see what the sense of this body is. And the sense of this body comes from the legal staff. I don't believe the legal opinion here, which took us, we didn't actually see it until the Budget Control Board got a hold of it. After all this conversation, and it's even less weighty than we thought. Now, we, of course, instantly allowed staff of the Budget Control Board and their lawyer to see these stuff. I don't know who made that decision, but the circle of trust gets larger as it fits the case. But we made them access to confidential information, which, by the way, they didn't want.
Mr. Lumpkin,
Yeah.
I don't think it's necessary to a resolution of the pending motion that we debate the merits of the staff. I don't think it's appropriate to do that. I'm not aware of a single decision this commission's ever made if it wasn't made by the commission. And that we instruct the staff to give us information, and they work diligently to give it to us.
Has the commission ever voted on the confidentiality issue? I think not, and I'd like to call for a vote right now. So my motion is on the table. Do we need it read again?
Is there? Yes.
Well, if we can continue discussion just for another second, just to read what happened at our joint meeting with the trustees, right? Fiduciary council was voted, approved, and engaged for the whole system. there's a request outstanding of us for any necessary suggestions on legislative changes that would enable us to better do our jobs. And I think for us to preempt that without further information is premature.
Is there any further discussion?
Yeah, I'll say something. You know, I think that this, I believe, you know, you could take most of these contracts, and Nancy's gonna strangle me when I say this. I was trying to be lighthearted and humorous. You could take the contracts and publish them in the state newspaper, and people would be bored to death. There's nothing there. I understand everything that's being said here, and I understand the Budget Control Board has offered that they would, not offered, they voted that they would look into this on a legal basis. But, I can't believe I'm agreeing with you 2 times in one meeting. But we need to move ahead.
Well,
And so let me finish, please. And so let's put it on the table and let's vote on it. And I seconded the motion, and there's just nothing there. I mean, why are we doing this? You know, we're demeaning ourselves. We're beating the staff up. Let's get it over with. So there's been a motion on the floor. Let's vote on it, and then let's move ahead. Please, for God's sakes.
Might I mention one more thing? I called half a dozen legal houses over Friday, Saturday, Sunday. No one's ever aware of a suit they're on in the instance that we're talking about. And also, we're not talking about just contracts. The confidentiality handles almost all information in this office, including due diligence and things like that. So there's questions like during the investigation, can SLED actually see these things? You know, I still have not seen the total file, even though I've been here 3 times to see one file. I still haven't seen the total file. And so until we get access to information, we can't make the decisions. I know the staff is not.
I'm sorry, when you finish, I'd like to know which file that is, because I want to make sure.
Timbo file. Have not, you know, all the budget stuff, all the email traffic, all the proposals, the real estate that was supposed to be given to us 10 days in advance, which wasn't, all those things that weren't complied with weren't in the files. And I've asked for them, I've been here 3 times. I'm also gonna come back again in 2 weeks and just see if they show up then, because every time I come, the file is different. So, I mean, we have process problems that are completely controlled by staff, and confidentiality keeps it all controlled by staff. I don't know about has any commissioner actually been into the files and been looking?
Can I mean, you just said something there that I gotta ask a question on. You talk about email traffic, you know, confidentiality being all things, that includes everything from HR, everything down, right? And what we're talking about here is full opening of everything from personnel files to, you know. Again, this is why I want more guidance, right? I mean, I think this is just particularly fraught with peril.
I'm only discussing the contract, the
Right.
investment files themselves. That's
Right,
all
but I think the way the motion is stated, that's unclear.
It's very encompassing.
Let's see. Well, it talks about investment. All this pertains only to investment files.
Read the motion again, please.
Okay, let me insert this properly now. Government staff of fiduciary, to include a budget and control board and state treasurer's custodian, shall have full access to confidential material concerning investment files. The access shall be decided by the fiduciary upon need and credentials of staff. Fiduciary staff who receives the information shall maintain its confidentiality in accordance with state law. All future contracts should explicitly provide full access to fiduciary staff.
So under that, what I'm gonna call the non-statutory fiduciaries, Would each have the ability to determine who they give the
That's right, the
inspection
governor
to?
will have the right to decide. The chief executive officer of the state would have the right to decide who she wants to look at. And that could be her lawyer, could be her chief of staff if it involves several officers. The same people who have access to HIPAA information at DSS and HHS, the same people who have budget information, the same people who sign the bonds, the same people who do all the confidential and multi-billion-dollar operations of the state, yes, they would have access.
Mr. Chairman, may I? Thank you. Having had a chance to listen to the motion twice, but not having had a chance to study it, I'm not sure that it's legally sufficient.
I have no doubt you would believe that. That's correct. But if it's not legally sufficient, I think that is taken into effect later on. If it's not
Well, that's-
legal, I mean, we
you know,
pass
one of
laws
the-
all the time that don't pass.
Mr. Lofton, one of the advantages of having the rules of order requiring motions be in writing, which we often waive because they're not as complicated as this, is that it gives, if they're in writing, it gives everybody a chance. And if they're on the agenda, it gives everybody a chance to think about it ahead of time, instead of having to think about it off the cuff. The motion has a lot of merit to it, but that doesn't necessarily mean that all the ramifications have been thought through.
Well, and neither is the present policy, which of course has never been voted on by the commission itself.
But the present law that was voted on by the legislature and signed by the governor.
Well, that's your interpretation of it, not the Attorney General's interpretation.
Well,
So, okay, so either I get a vote or I don't, and I have it out there for a vote.
is there any further discussion? Anybody else want to say anything?
If I may.
Okay.
Well, I have a question. At one prior meeting, I thought that the commission and treasurer's office, we had decided that we would employ an outside entity to guide us on the issue of confidentiality. But now we have budget control.
Yeah.
at stake. Now, is that simultaneous or are these
That's
two
simultaneous.
separate, are these two separate actions? or-
No, I would view it preferential to look to the Budget Control Board, because this basically comes up with interagency information sharing, for lack of a better term, right? Because normally in other systems, right, everybody's part of one agency, right? We have the joy of having the state law that's now split responsibilities across 4 effective bodies, right? PIVA, the trustees, the treasurer's office, and us, right?
And the retirement system.
And the retirement system, so five bodies, whereas I think other states, it would all be contained in one unit, right? And I think that creates, in fairness for legal, right, that creates legal ambiguity, right? I think that can be worked through. I think fiduciary counsel for the system as a whole can opine on that issue. And I would prefer to wait, and I think if there are changes in need of clarification, it seems like we have to support budget control, which I would imagine with unanimous support to get it through legislator and get a lot more clarity than we as a body, I think, are in a position to do.
I think that's an important point, and I think that proceeding as is suggested presently might actually cause us more difficulty and muddy the waters a little bit. I don't know what the timeline is for this procedure that the Budget Control Board is instigated, but what are we talking about time?
We don't have information
Well,
present to find out.
and the other issue is, again, a lot of this comes down to contractual stuff, and the last contract we saw in the last letter I received, and correct me if I'm wrong, Mr. Treasurer, y'all were okay with the language in it, because we did extend it very directly in contracts going forward.
Right.
So, so in my mind, I don't think operationally on a go-forward basis it's an issue, but I would, to the chairman's point, want better clarity on kind of what's in the ground before I take an action that opens a can of worms, of unintended consequences. right?
I understand that there's not an elegant solution to this. There's nothing that's going to be just right. But either we allow fiduciaries to fulfill their responsibilities and have access to information, or we don't. And for fiduciaries who have not chosen this career, like say Hurstville here, has been doing this for a long time, he wants to continue to do it. That's his chosen profession. Feltner, myself, Senator Leatherman is not our chosen profession these things. We do have responsibilities and we have liability. And so we've got to move forward on this. As I think about this stuff, it just is gonna last on forever and ever and ever. And then at the end of the day, we just still have an opinion. We've got the people stuff to work out. I mean, I don't think.
In the interest of moving the agenda along, let me recognize Herschel. You wanted to make a comment earlier.
Yes, sir. Thank you, Mr. Chairman. And in my thought, in my position is to always be reflective on why I'm here and who I serve. And it's a sole fiduciary responsibility to the participants and beneficiaries of the trust. And that my job or role responsibility is to protect that trust, make the best investment decisions for the highest returns with the level of risk. That's my function. And so my comments are based on that. That historically, as the commission evolved, we've had multiple treasurers who've all been part of all the decision-making and the contracting phase for all the legacy contracts. Treasurer Loftus has decided to take a different view than other treasurers and wants to be much more engaged with respect to his duties as custodian. That in itself is a change to the overall process. We have been trying to work through what a better process is to meet his duties as well, and also protecting the trust, and we're all working towards the same goal. I think we cannot lose focus on why we're all here. The latest with one of our contracts actually had language to give access to the treasurer staff, and I think going forward, that is the language we're working towards to make sure that the treasurer staff has access to those contracts. I would agree with you, Mr. Chairman, that we do have legacy contracts that have different confidentiality standards and protections around them. We have in the past worked with certain managers to put in place confidentiality agreements that would cover his staff. My understanding is those were not signed. If there are issues around negotiation of that confidentiality contract with those particular managers that grant access to his staff for reviewing those, then I think we just get through those process and make sure there's a confidentiality blanket that would cover legacy contracts so that we do not harm the trust. And I think that is my primary concern. I think that if we do change the process and the way that we go about allowing broader access to information, that in itself, we have to be wary of how that changes the investment process or potentially impacts the available investments to the trust as well. That will have an impact. Now, I'm not saying there's a right or a wrong, but that is a consideration as well. And I think that everything we do needs to be focused back on our sole fiduciary responsibility to the participants, the beneficiaries of the trust.
No, I couldn't agree more. So what we have is not much movement here.
Well, I think we're getting ready to have a vote. Travis, did you have anything you want to say?
He just brought up one thing here. Let's see how in the real world it works. We've been talking about the Timbo thing for a long time. Has any?
Timbo?
The timber.
American
Oh,
Timber.
American
okay.
Timber. Try not to use the name. We called it Timbo in the documents, Nancy. I think, has any commissioner gone to look at the files? And we've been talking about it for a couple of months now. I brought up to both lawyers that I thought serious impropriety had been at the time. Did either of y'all research it? Go back to it?
We can discuss.
Well, I mean, but this is the
Wait a
confidential.
minute.
This
is
has
not
to do with
germane
confidentiality
to
of the files.
pending motion.
This
It's
has
not
to do-
germane to the pending motion.
I
I'm
think-
ruling that is out of order.
Well, it is, well, you rule it. You rule my agenda item out of, I expect, I'm prepared for a lot of this. But
Curtis, you're swimming, as we said in
I
Australia,
know.
you're swimming outside the ropes
You're right.
here, okay? You really are.
Well-
Um,
I mean, we are getting into matters of
There's that, yeah, we can talk
personnel or
this.
confidential.
We got a
legal.
motion on the floor and.
Well,
I think what you're talking about is more a subject for executive
Well, nothing I
session.
said was confidential. What I was trying to get to was how these files are treated. And if the treasurer can't get staff to go through them, and can't get commissioners to go through them, who's supposed to go through them? Now, you know, I've asked for a vote a long time ago, and it never did get done. Did y'all, who was it? Somebody said that we should change.
Are you calling
change this
for a question?
Yeah.
Is there a second?
They said that we should, and
That
I think we
doesn't require a
did, this. Should be the
second.
treasurer, right?
All right.
We were
That
limiting this
doesn't
to the
require a
treasurer
second.
staff, right? Somebody said that.
All in favor of the question?
I'm way confused now.
Okay. Jim, was it you? Who?
I seconded your motion.
For the treasurer staff.
And so, but I have, and it has been amended to include, to
All investment policies.
specifically limit it to investment matters.
To investment matters of the treasurer's staff.
All right, Travis has called the question. We need to have a, procedurally, we need to have a vote on that. If that passes, then the motion will be reread immediately before the vote. So all in favor that we proceed to the question, say aye.
Aye.
Okay, two-thirds has it. Now, please, whoever has the motion written down accurately, please read it.
I think I did.
Are we back in discussion on that? Can I just ask one follow-up question? Or
Well, we've called the question.
We've called the question.
With
so we gotta
unanimous
actually vote on it.
consent, we can let you do that. Yes.
Right.
Does anybody object? Okay.
Given that the way this motion is worded, but you had some prior correspondence, Mr. Treasurer, with Chairman Williams about a proposal on how to address legacy contracts. I would like for the motion to reflect that procedurally so that we don't, on an unintended basis with a vote right here, open up a can of legal, which basically was to send out a certified letter, if you could just kind of cover that procedurally, because I don't want this
Well,
vote to.
what I had, we didn't agree. You know, his was that all of the contracts had to go and be amended. And when we read the contracts, it's clear that anybody who's invested, anybody who works on the day-to-day basis of either the investor or the fund is included in these contracts. And they call them affiliates, they call them interested parties, they call them advisors, they call them all sorts of things. But then it comes down to, in one way or the other, that's what they are. I called New York, talked to somebody, written 500 of these.
Can I touch on any of that? Because this, again, is kind of a procedural question, but I would love to know the treasurer's office thing. Advisor to the fund and presumably advisor to us. So if Bill comes across and look at it, is he now engaged as our attorney?
Well, he wouldn't necessarily be an
Subject to
advisor. I mean, there's different ways they call them affiliates that are, and generally those affiliates are people who are
Right, but that's
exercising the
legitimate.
day-to-day.
But if he's an affiliate, he would still have responsibilities back to us, right?
Yes, yeah. I mean, he can't go out and do things he's not supposed to do. He's got to abide by the confidentiality. He's got to sign with contracts or whatever training we go through. You know, the affiliate things go both ways. The fund, they have auditors, lawyers, accountants, valuation people, property management people in the case of real estate. All of these people are able to get into this as long as they are in the day-to-day operation necessary to the fund and sign on to what you have to do, which is confidentiality. You can't talk about
I think we've gone further than we should have gone once the question's been called.
Shall I read it for you, Chairman?
Please.
Can you comment on whether it just applies to new contracts going forward or whether it opens?
All contracts.
All contracts,
Yes.
including legacy contracts, regardless of what the confidentiality.
Because we've looked at about 10 now. I've looked at about 10. With my WikiLegal and WikiInvest and all that. And just can't find these prohibitions. Just can't find them. And so, is there one someplace that picked me out by name? Maybe, I don't know. But I don't think so. So, anyway, the motion would be government staff of state treasurer as custodians shall have full access to confidential material of investment files. The access shall be decided by the treasurer upon need and credentials of the staff. Fiduciary staff who receives information shall maintain this confidentiality in accordance with state law. All future contracts should explicitly provide full access to treasurer's fiduciary staff. You know, I shouldn't call it fiduciary, treasurer's selected staff.
Read it one more time, please.
Government staff of state treasurer as custodian shall have full access to confidential material of the investment files. The access shall be decided by the treasurer upon need and credentials of staff. Fiduciary staff who receive information shall maintain this confidentiality in accordance with state law. All future contracts should explicitly provide full access to the treasurer's selected staff.
What is government staff, and what does that word mean? I don't know.
Government means the work for the government.
Oh, government.
Oh, yeah.
Okay.
Just a question, is that maintain confidentiality in accordance with state law and the provisions of the contract?
Yes, ma'am. State law on calls, we're happy to.
Okay.
You make said determination. No.
Well, the same people make it for you, Nancy.
No.
The same people make it for you.
Do we need the motion read back one more time?
Yes,
or-
we do.
Okay, read it back.
Government staff of the state treasurer, as custodians, should have full access to confidential material as pertains to investment funds. The access shall be decided by the treasurer upon need and credentials of staff. Fiduciary staff who receive information shall maintain its confidentiality in accordance with state law and contracts. All future contracts should explicitly provide full access to the treasurer's selected staff.
Right.
Amen.
Ready to vote?
Can I ask one more question?
Yes, sir.
What do you mean by today?
You know, it wouldn't be, we'll have to be a lawyer or investment professional, somebody who has a direct need to manage something. We might have a banking issue, say with Bank of New York or something like that. So you may have to include the banker. But, you know, the fiduciary picks up the responsibility. It's got to be a small group of people.
I think that's a good clarification.
Yeah, thank you, sir.
Well, can we get it in the motion if it's a
Mhm.
clarification, please?
Correct me if I'm wrong, but I think there may be a contradiction in that last sentence where it says that, where you state that staff will maintain confidentiality in accordance with the contract.
State law and contract, yes.
Well, if the contract says something about confidentiality, and you're suggesting that the staff would then be bound by the contract, isn't that a bit of a contradiction, or am I?
Well, the confidentiality clause generally are there to keep proprietary secrets, business secrets, trade secrets, individual positions, help me if I'm missing something, those type of things we're getting at. That's the whole point of the contract. Fees, from the general public. Because what they don't want to do is you take it and give it to their competitor, or something like, put it in the newspaper or something like that. And of course, my office and myself personally would pick up responsibility for these things.
Do you have another question?
The definition of credentials, what
Help me, Professor, help me.
well, well, you just mentioned investment credentials, right?
Such as investment, legal, et cetera.
Well, not et cetera.
Well, you know, like you'd have to have your chief of staff would have to have.
Legal and investment.
Yeah, legal investment, but you'd also have to, well, and your chief of staff, because your chief of staff got to manage the information, get it to the right people, just like they do here. Such as legal, investment, and chief of staff.
How would a chief of staff have credentials? I don't understand that.
Well, this one was approved by the United States Senate in 100-0 vote. He's got credentials.
As an investment professional?
No, as the person who's going to take the information and say, all right, this has got to go to the bankers, this has got to go to the lawyer, this has got to go to Curtis. Same as it works here, right? Adam, you see contracts if you need to.
I guess one concern I have is that who makes the determination if it goes to the banker, and then is the banker then covered under the confidentiality?
Yes.
Under this proposal as written, that would be the way it would.
It's same as in this office. It's the same thing. There's no difference. The banker who Paul Jarvis handled $34 billion last year, plus y'all's money aside, he's got a pretty good track record. You know, he's in the guts of a lot of things, these big corporations, big banks, all these things. We handle the paychecks, we handle doctor's checks, all these things. We handle confidential information every day. While everybody's awake, can we have a vote? Oh, I'm sorry.
Well, I mean, we're out of discussion. I liked your proposal about how to go back. I mean, I just want to say for the record, I'm uncomfortable until I know, until we've looked at them, on the historical stuff. Not that I don't think it needs to be looked at, but it makes me highly uncomfortable.
I like that proposal too, but that wasn't the proposal that came back. The proposal that came back was staff would contact and may or may not amend, and it was a long, lengthy process. And effectively what it does, it gives the treasurer fiduciary responsibility when the chairman allows it. I'm just not going to put up with that.
Well,
That was
My
a letter
letter
back and
speaks for
forth between
itself,
y'all,
and I
and it wasn't
think,
Commissioner
obviously,
Biden.
that's a characterization I wouldn't
So,
necessarily.
would you like to read the letter? Got it.
I don't think that's necessary. I think every commissioner has read the letter.
Okay.
And it anticipated that the commission would endeavor to accomplish these things with future and past contracts. The commission would include the commission itself
Well,
and the
that-
staff. Ultimately, the commission is the
But that
vote
letter came
of our
from you,
a majority.
didn't
It came from me as my proposal to you,
Mhm.
to solve a problem that we have a mutual
But the commission
interest in
didn't discuss
solving.
it. You wrote the letter.
Yes, of
Okay.
course.
Well, that's right, but you just said the commission, so the commission didn't, you wrote it. And so
My
that's-
proposal is
Yeah.
that the commission endeavor to change future and past contracts in accordance with what we wanted to do. That was my proposal. If you had accepted my proposal, we would have been here today with a joint, and been in the budget control board with a jointly agreed upon mechanism, which would be substantially identical with what you just said.
And if you had suggested, accepted my proposal, which was to certify a letter to all these people, which is what the treasurer's office is doing right now. We're gonna write each one of them and tell us why we can't see it. And I got a feeling we're not gonna get a single letter back that says we can't see it. So that was our proposal. We put it out there, we didn't. I would like to pay somebody to have a vote. How about y'all? Can I give somebody $20 for a vote?
I don't think that's legal.
I don't condone
I
that.
don't have any money, so there we go.
I'll take the $20.
All right, is it time to vote now?
Yes, sir.
Is somebody ready to recall the question?
I'll recall the question.
All right, all in favor say aye.
But can I hear it one more time?
Got it.
$30. Okay. And we're glad you're here for your first meeting. Government staff of the state treasurer, as custodian, shall have full access to confidential material as it pertains to investment files. The access will be decided by the treasurer upon need of credentials such as legal, investment, banking. Fiduciary staff who receive information shall maintain this confidentiality in accordance with state law and the contracts. All future contracts should explicitly provide full access to the treasurer's selected staff. Okay. Call for question. That was clear.
Well, I mean, we have a motion, which I guess procedurally we need to deal with, but I do have kind of a legal question. If legal comes in from outside, right, do they become effectively our legal counsel? Are they counsel to us as a body at that point?
There's no such obligation.
Nobody's thought that through.
Well, you mean ours? So.
Yeah, like when
Well,
he comes in and
look,
looks at
let's just
investment
vote, because if y'all think my lawyers can't see it, we need to vote
No,
and
I
vote it
don't,
down.
it's not about that, Curtis, it's about trying to understand,
Yeah.
right? You know, if he comes in and sees something, does he now have a duty to report it back to me? I would love to know.
Well, I don't,
Right.
well,
Or
wait,
is the
wait,
duty of
ours
Commissioner
don't have
Little
a
back?
duty. Ours don't have a duty. I spoke to both of ours, and ours did not raise a duty.
Mr. Loftus.
Tell me where you did.
Would you please?
Tell me where you raised the duty.
Tell me exactly when you and I had this discussion.
You and I sat in that conference room for about 3 hours together, going over
You
these
tell-
phones, and we
No,
discussed
sir.
it at length. And I told you
No,
more
sir,
than that.
I want to
I will bring the notes in,
exactly
and I will bring them and certify them.
when
And I had the
what
same
issue
conversation.
you raised with me.
Chairman, can we bring this back in?
Yeah,
Please.
I'll have the same conversation. I will provide my
Just-
notes, which were taken at the same time.
I think we've gone far enough
Yeah.
into that. I was,
Chairman, I
Ms. Shealy
apologize.
deserved a chance to defend herself, but I don't think we need to go into this yan any longer. Alan, you still wanted something to clarify?
Yeah,
The legal, who would those lawyers represent?
Yeah.
They represent me.
Well, I think that's the answer.
Huh?
I believe that is probably the answer. I don't
Yeah, that's
believe
the answer. And that's one of the ramifications that needs thinking about.
Right.
So is the suggestion that the treasurer can't have legal representation?
No.
No, I just
no,
want to
no.
understand the issue,
Right.
right? Because, you know, let's say Bill Condon and your legal staff takes a different legal opinions, right? And we know legal opinions get, you know, mediated and litigated, right? And so they take a, you know, I would like to know that prior to the fact, right? Right, if they don't represent me.
All right,
And not me personally, I mean us as a body collectively, right?
unless I hear some disagreement, I think all the relevant opinions have been aired, and it's time to vote. Does anybody disagree with that? All in favor of the pending motion, signify by saying aye.
We're voting on
On the
The
treasurer's.
motion.
on the treasurer's motion.
As it was worded.
As it was worded. Okay.
All in favor, signify by saying aye.
I vote for the motion, actually.
All
And
opposed?
Travis, well, I want to make sure.
So we have a tie.
Travis voted for it. I voted for it. I vote for the motion.
Motion favors it.
3-3. Okay.
Okay.
Mr. Chairman, if I may, I owe the treasurer an apology. I got our topics mixed up in terms of confidentiality and access to records. Yes, you and I did discuss that. And I thought we had made some progress towards some resolution between the two of us as well. And I apologize, I got the topics confused, and I stand corrected.
May I say something? Ms. Shealy, you were employee number 1 for this commission, and you don't owe anybody an apology for anything. Mr. Chairman.
Here. It's ready to move to the next agenda item, but before that, I want to make clear, I have requested staff to do this review of existing confidentiality agreements. I have not looked at the language of any particular one. I didn't have to, I don't recall having to sign any when I was chairman. If I did, I looked at those obviously, but at least for the private equity field and this venture capital and all that, I think it's important that analysis be done, and I expect an analysis and a report at the next commission meeting.
So am I correct to believe that no commissioner has read one of the confidentiality?
I can't say what other.
Yeah, I mean, we've read some of them, but, I mean, there are a lot of them out there. Yeah, I've seen and been going back through them, but obviously there are a lot of them.
Yep.
And so, I mean, I would just like to say procedurally, I would like for us to move towards the proposal in the treasurer's letter. However,
As
as
would I.
related to that vote, I was uncomfortable.
Mr. Chairman, if I may say, it's just a practical timing issue. We only have one investment that's set to close in the near term, and that's in that asset, and I don't think it's private equity. And so if the Budget Control Board acts quickly with their fiduciary counsel, we may have some more guidance for the next time we go through this review issue. So time may be on their side if the fiduciary counsel comes back.
Well, it's going to be a while.
So with that said, that contract, which has been discussed in public with Johnston, was an international equity manager, Commissioner Powers participated in that.
I've been involved, I was involved in that due diligence process.
So the decision was to allow the option to close on the Lighthouse platform. However, there were other investments closed on that platform that seemed to cause some concern. So, and then also the treasurer's concerned about out-of-bank versus in-bank assets. The election is to work with Johnston to create an IMA and a separate account, which will require global custody for the treasurer's office as well.
Thank you.
The only other contracts, I believe, were approved in April 18th. I believe those have all been reviewed and approved and signed. September 20th is our next scheduled commission meeting, which there are a series of investments to be proposed at that committee meeting for approval as well. So we do have a couple of months to continue to work through some of these issues.
Okay. Mr. Gillespie, you want to make a motion now that we go into executive session?
I'll make a motion that we move into executive session for purposes of discussing personnel matters and receive legal advice.
Yeah, is there a second to that?
Yes.
Let's vote on that, and then we'll take a break before we go into executive session. All in favor, say aye.
Aye.
All right, we're going to take a break, take about 10 minutes to regroup, I think. And this session will be closed to every